This episode departs from our usual format to highlight 3 memorable moments in which judges reprimanded attorneys appearing before them. Our first admonishment took place in the 215th Judicial District Court in Houston, Texas. On June 23, 2025, plaintiff Lawrence Kuykendall filed a civil suit against defendant Turner Jones. The case was presided over by Judge Nathan Milron, and Mr. Kuykendall was represented by attorney Eric Rodas. On January 28, 2026, Mr. Rodas filed an application for temporary injunction and temporary restraining order seeking to halt an auction for the issuance of 1 million additional shares of the parties' jointly owned business. The court granted the temporary restraining order that same day and on February 13 denied the application for temporary injunction. On the morning of February 17, Mr. Rodas failed to appear at a hearing, then approached the clerk later that afternoon requesting an emergency hearing to stop the sale of stock. The court set the matter for an in-person emergency status conference on February 18 at 8 a.m.
Mr. Rhodes, tell me why we're here today. You asked for an emergency hearing from my clerk yesterday verbally.
Yes, Your Honor. Well, we're here today, Your Honor, because the court set the emergency hearing for.
Because you requested one, sir.
Your Honor, what happened was...
You didn't appear at my hearing yesterday again.
If I may respond, Your Honor?
Please, I'm waiting.
So, Your Honor, as it relates to yesterday, and non-appearance for yesterday, the short answer is that it was not on my calendar.
Were any of the other 6 hearings you didn't attend on your calendar?
Your Honor, I don't believe it was 6 hearings that I missed.
You want to go through the record again?
No, Your Honor. But, Your Honor, what happened on yesterday, as relates to our hearing, as the court is fully aware, there was a TI hearing which was denied regarding the sale of the stock.
And you're getting ready to go back to the ancillary and try to overturn me again, right?
No, I'm not going to do that, Your Honor.
I assure you, you're not.
Okay, so what happened, Your Honor, there's been communications between me and opposing counsel, in particular, going back and forth and trying to get the matter resolved as the case would be. It wasn't until late yesterday, Your Honor, not to violate attorney-client privilege communication, it wasn't until late yesterday that I was directed to seek, if it was possible, to go and see if we could have it modified. At that moment...
Why would I modify it after you've had 6 weeks to modify it?
Your Honor, I was instructed to do it by my client.
Where's your client?
My client...
I instructed him to be here today. Where is he?
Okay. I have no...
I'm about to issue a bench warrant. Where is he?
Your Honor, I have no idea where my client is.
Okay.
But Your Honor, may I explain?
You may not. I'm asking where your client is. You don't know.
Your Honor, if I may explain. When I called, the court advised that we had an emergency hearing scheduled for this morning.
At your request.
I advised my client of the emergency hearing on a status conference. The emergency hearing on a status conference.
That he was ordered to appear at.
Your Honor, by the time I got the order, I was driving while I was speaking.
I understand. You did it late in the day, and I did it late in the day.
By the time I got the order and tried to reach out to him, I could not reach out to him. I could not contact him.
Why don't you contact him right now and see where he is?
If I may, Your Honor?
Yeah, absolutely. We'll do it on the record. I'd like an address where he is because I'm about to send out the constable.
This is probably the 10th phone call that I've made.
Please record your
And
message.
this is what I get. I sent an email. I've sent text messages.
When did you send the last email to him?
Last email was sent to him probably at about 5 o'clock this morning.
Why don't you show me that email? Mr. Rhodes, frankly, I don't believe a word you're telling this court at this point. Deputy, find out who's in my ready room, please.
Actually, by way of correction, Your Honor, the last email sent out was at 7:24 a.m. this morning.
Okay. And your client doesn't want to respond to this case? Does your client want to prosecute this case anymore, or should I dismiss it?
No, yes, he does, Your Honor. He does want to prosecute the matter. Your Honor.
Where is he?
I have no idea where he is.
Go find him right now.
May I be excused?
Yes. Y'all can step back.
All right.
Mr. Rhodes, any luck?
No, Your Honor. No luck in contacting him. Mr. Simpson, Attorney Simpson, was able to contact the daughter, who advised that he was in Port Arthur, and also provided me with another number. I tried contacting that number multiple times, and it just goes straight to actually not even voicemail, says that it's full. So.
It's clear to me your client doesn't want to prosecute this case. Why didn't you appear for 6 weeks? And then you appeared last week on Friday. You didn't appear yesterday, and now again this morning, you're requesting emergency relief from this court.
Actually, Your Honor, as I mentioned earlier, I did not appear yesterday because the hearing was not on my calendar. When, as directed by my client to see if there was availability to have an emergency hearing, not today, but later next week.
Well, you're not getting anything later next week. I promise you that.
I completely understand, Your Honor. I was advised that they wanted to have the hearing this morning, and I advised the court that we were not seeking a hearing to seek relief for today.
Well, but that was after you requested relief from my clerk, and she reached out to me late yesterday afternoon. Tell me what I do to make this right for everybody else in this courtroom that has spent their time and money this morning.
I don't have any suggestions, Your Honor.
All right. Well, I do. You're going to pay sanctions in the amount of $5,000. Get out of my courtroom now. And those sanctions are payable by you directly, not your client. I will sanction him directly in the future. Get out of my courtroom. Y'all are excused. Y'all on the 8:30 docket, have a seat, relax. I need a bench warrant. I want him arrested. I need a bench warrant. I want him arrested.
Milron orders Mr. Rhodes to personally pay $5,000 in sanctions, specifying that the amount is not to be paid by his client, and directs the issuance of a bench warrant for Mr. Kuykendall's arrest. As the Court of Appeals of Texas explained in the 1992 case of Kutch versus Delmare College, Texas courts have the inherent power to impose sanctions for conduct affecting core functions of the judiciary. The Supreme Court of Texas determined in the 1998 case of In re Bennett that this inherent power includes the authority to discipline an attorney's behavior through sanctions instituted on a court's own motion. Whether a particular sanction is quote-unquote just as governed by the 1991 case of Transamerican Natural Gas Corporation v. Pell, where the Supreme Court of Texas held that constitutional due process requires that any sanction imposed not be excessive. Well, under this standard, the reasons supporting the sanction, including Mr. RHS's non-appearance at properly noticed hearings, must be weighed against his due process rights for the sanction to pass constitutional muster. Our next courtroom reprimand occurred during the high-profile Parkland school shooting case. On February 14, 2018, a former student opened fire at Marjorie Stoneman Douglas High School in Parkland, Florida, killing 17 students and staff members. Following his guilty plea, defendant Nicholas Cruz proceeded to a penalty phase trial in Broward County before Judge Elizabeth Scherer, which concluded on October 13, 2022. When the jury could not unanimously agree on a death sentence, leaving life in prison without parole as the only available outcome. On November 1, 2022, the court held the first day of a two-day sentencing hearing, during which the families of the victims were permitted to address the defendant directly. After one witness commented that the defense attorneys would have difficulty facing their own children after representing Mr. Cruz, the defense.
No one jumped up to try to tap down that rhetoric. That is the rhetoric that I'm talking about. That is what I'm trying to be very clear on. Jeff Marcus, the state, they can hide behind their arguments, but we all are witnessing what is occurring in this courtroom.
Which is myself. I'm a judge, and I understand that I'm in charge of the decorum, and I feel that 99% or a great percentage of what has been said has been appropriate. Everybody has maintained decorum, but for a few comments, it's best to just move on as opposed to highlight them.
This is true, Judge, but I am witnessing a building of momentum, and I'm encouraging the court to direct the state to tap down on that momentum so it does not reoccur and it does not become a theme. Thank you, Judge.
Your Honor, for the record, the only thing the state has said to any of these witnesses when they get up is, would they like to say something on behalf of the victim they're representing? There's been no encouraging or inciting, as Mr. Weeks has put on this record. That is a blatant falsehood and a recreation of the records. As far as no objections being made, it's the defense that could have objected. It's not the state's duty to object to their own witnesses when they're testifying.
Okay. Listen, I've already heard. If you have anything else to say, you can put it in writing at a later time. I've heard from both sides more than once. That's going to be it. I've made my decision. Like I said, 99% of what's been testified to has been appropriate. I do not want to highlight the few things that were said that were perhaps not appropriate, and let's move on.
There's a message for 20 seconds next.
You can have as many seconds as you want in writing, and you can put all of your objections in writing. They've been made multiple times from your chief assistant, from Ms. McNeil, and I don't want to hear anything else. I've already heard it. Is there something that has not already been argued?
Yes, ma'am.
Okay, exactly what is it?
Judge, before Mr. Schachter took the podium and testified before this court, I wanted to reflect that both Mr. Marcus and Mr. Satz looked at the statement prior to the briefing. And so their implicit adoption of what he was saying, of his improper arguments, according to the court should.
Okay, but what you are doing right now is highlighting something and making more of a spectacle. So if your office in general does not want to facilitate and or incite violence, then we need to just sit down and move on. That's it. There were 18 witnesses, 16 or 18 witnesses that testified today. There was nothing that was said until Ms. McNeil made her point made, and, you know, we're moving on.
But is the court going to do anything about maybe stopping it from happening again?
When these people are upset about specific things that have gone on from that table, like shooting the middle finger up at this court and laughing and joking, Ms. McNeil, be quiet. When these people have sat in this courtroom and watched this behavior from that table, and they want to say that they're not happy about it, what is the problem?
Judge, I have no problem because I have thick skin. But once you bring in my children, I think that's highly improper. I
didn't even know you have children. I don't know what you're talking about. Your children? What about your children?
But then to comment on my children is highly improper. Before this court to allow that kind of testimony is also improper.
There was... I don't remember any comments about any children. And if there was, it obviously didn't, it came and went without me noticing it.
Judge, I can assure you that if they were talking about your children, you would definitely notice it.
You need to sit down right now. You're out of line. In fact, you're excused. You need to go sit in the back with your chief public defender.
He's the public defender, Judge.
Mr. Weeks, please ask the lawyer from your office to go sit down and not say anything else. To try to threaten my children and bring up my children is inappropriate. Go to the back of the room now. That just violated about every rule of professional responsibility that I have never. If you're going to get up here and you're going to...
Judge, I asked you to go sidebar on this matter.
You, sidebar or not, you don't have one of your assistant public defenders say something about my children?
Judge, that same venom that the court is expressing is the same venom that defense counsel had to sit through this entire morning.
She brought up her children multiple times during the trial. Nobody knows if I'm barren or not. They don't know about my children.
Judge,
sit down. Sit down.
Judge.
Sit down, Mr. Weeks.
Please do not summarily dismiss me.
I'm summarily dismissing you. Go sit down.
I'm asking the court. I asked the court to go sidebar.
Go sit down. You don't threaten the
Judge,
court's children.
Everyone in this courtroom.
Go sit down.
No one in this courtroom had to endure what we have to endure.
Go sit down. Miss McNeil has made her children a spectacle more than once during this trial. That was her choice. You have absolutely no right to have one of your assistants come up here and suggest something about my children. Now, please go sit down.
Judge.
You're inappropriate and out of line. Go sit down.
Judge, may I have a brief recess?
No. Go sit down.
May I have a brief recess so I can speak to my attorneys?
We're moving on with the sentencing, Mr. Weeks.
So can I have a brief recess?
No.
Thank you.
It's 1:36. Thank you. State, go ahead and call your next witness.
Mr. Anthony Montalto.
Judge Scherer
raised the
rejects
issue
the
with
defense
Judge
team's
Scherer,
objection,
arguing
and
that
following an
references to their
exchange in which
children
defense
were
attorney
improper
David
and should be
Wheeler
out of
referenced the
bounds.
judge's own children
Judge
while
Scherer
pressing the
rejects
argument,
the
directs
defense
him to be
team's objection
excused from
and
the defense
following an
table and sent
exchange
to the
in
back
which
of the
defense
courtroom.
attorney David
Florida
Wheeler referenced the
jurisprudence has
judge's own children.
consistently recognized that
While
courts
pressing the
possess
argument,
inherent
directs him to be
authority to
excused
manage
from
the
the
proceedings
defense
before
table
them.
and
In the
sent to the back of
1978
the
case of
courtroom.
Rose v. Palm Beach
Florida
County, the
jurisprudence has
Florida Supreme
consistently
Court explained
recognized
that courts have
possess
the inherent power
authority
to do
manage the
all
proceedings
things that
before
are
them.
reasonably necessary to administer
1978
justice
case of Rose
within
v.
the scope of their jurisdiction,
Palm Beach
subject to
County.
existing laws and constitutional
The Florida
provisions.
Supreme Court
And in the
explained that
1952
courts
case
have
of
the inherent
Petition
power
of
to
Florida
do all
Bar, the
things
court
that are reasonably
described that
necessary to
inherent
administer
power as extending to
justice
the
within the
incidents
scope
of
of their
litigation,
jurisdiction,
control of
subject
the
to
court's
existing
process and
laws and
procedure,
constitutional
control of the
provisions.
conduct of its officers,
And in
and
the
the preservation of
1952
order
case of
and
Petition of
decorum with
Florida
reference to its proceedings.
Bar,
Now, as
the
to the
court
underlying
described that
objection that
inherent
prompted
power
the
as
exchange,
extending to
the
the
scope
incident
of
of
what
litigation,
victims may say at
control of the
sentencing
court's
is governed by
process and
Section
procedure, control of the
921.143 of the Florida statutes,
conduct of
which
its
provides that
officers, and the
statements by
preservation of order
victims
and
and next
decorum
of
with
kin
reference to
shall
its
relate to the
proceedings.
facts of the case
Now,
and the
as to
extent of
the
any harm,
underlying
including
objection that
social,
prompted
psychological, or physical
the
harm,
exchange,
financial
the
losses,
scope of what
loss of earnings
victims may
directly
say
or
at
indirectly
sentencing is
resulting
governed
from the
by
crime,
Section
and any matter relevant to an appropriate
921.143 of the
disposition
Florida
and sentence.
statutes,
This
which
statutory
provides
framework is reinforced
that
by Article
statements by
1,
victims
Section
and next of
16
kin
of the
shall
Florida
relate to the
Constitution,
facts of the
commonly known as
case and the
Marcy's
extent of any
Law,
harm,
which
including
guarantees
social,
crime victims the right to be
psychological,
heard in
or
any public proceeding involving
physical
sentencing.
harm,
Neither
financial
Section
losses, loss of earnings
921.143
directly or
nor
indirectly
Marcy's Law
resulting from the
expressly
crime,
addresses
and any
statements
matter
directed at
relevant to an
defense
appropriate
counsel or their
disposition.
families. And here,
And
the defense's
sentence.
objection rested on
This
the position
statutory
that such
framework
references
is
fell
reinforced by
outside
Article
the
1,
scope of
Section
permissible victim
16 of the
impact
Florida
testimony.
Constitution,
Now, our third and
commonly
final rebuke comes from
known
the
as Marcy's
14A
Law,
District
which
Court in
guarantees
Washtenaw
crime
County,
victims the
Michigan.
right to
On
be
October
heard in any
30th,
public proceeding
2025,
involving
defendant
sentencing.
Samuel Peoples appeared before
Neither
Judge
Section
J. Cedric Simpson in a pending
921.143
felony case to address a
nor
request for a
Marcy's Law
competency
expressly
valuation
addresses
and a
statements
bond
directed at
violation
defense
arising from his
counsel or their
tampering with the
families.
electric monitoring tether
And
that he had
here,
been
the
released on.
defense's
Mr.
objection
Peoples was
rested on the
represented by the Public Defender's
families.
Office, with Assistant
And
Prosecuting
here,
Attorney
the defense's
Rachel
objection
McDuffie
rested
appearing
on
for the
the
state.
Court does call the cases of the people versus Samuel Peoples.
And Alex Warren Green on behalf of Mr. Peoples. State your name, Sam.
Samuel Peoples.
Your Honor, Mr. Peoples has not yet been referred to the Forensic Center. I've prepared an order, and we are asking the court to order a forensic examination of that case.
I will order a forensic examination without objection.
Your Honor, in the bond violation matter, we'd ask to continue our plea of mute at this time. That bond violation arose from the charges he is now facing in felony case 1326. Ms. McDuffie apprised the court that there is a tether tamper, which gave rise to the bond violation. He has been charged with a felony for tether tampering, so I think at this time
He has been?
He has, yes, Your Honor.
That's the new one.
There is an error on the complaint. We are having that amended. It should be a general tamper versus the category this was in.
Yeah, this is wrong. Okay. All right.
We would just ask to continue our plea of mute and continue these cases to the competency hearing on.
So is he just going to remain in custody?
Your Honor, he's working with a social worker. Between now and October 30th, we are hoping to file a written motion. I think something substantive that gives the court a better idea.
What's the objection in releasing? The thing is that as I understand the cut on the tether, he cut the tether, but he didn't go anywhere. He was right there when they went to go get him.
That's my understanding as well, Your Honor. If the court would consider it, then I'd ask that he be released back to home confinement.
I had all that anxiety.
Ms. Squams?
Your Honor, obviously we had an extended conversation about this at bench at the last hearing. I don't have any objection to him remaining on the conditions that he was on prior to this incident. I'm fine with him returning to home confinement for previous terms.
Mr. Peoples, if I let you go back home, you're going to cooperate and do the right thing?
Yes, Your Honor.
Okay, that means you can't tamper with the tether.
I understand now.
You understand that?
Yes.
Or you understood it before, you just did it?
I had a moment of anxiety that led to a freak out, and I felt like I needed to get it off me because it was claustrophobic. And
Got it.
yes,
I hear you. It's going to be part of the issue. I don't know if there are funds available to try to deal with the payment for that strap.
It's certainly something I can ask his family. They are here today.
They are here.
That's correct, Your Honor.
All right. Samuel,
yes, Your Honor.
I give you another shot. You're going to try to do the right thing?
Yes.
Okay.
Thank you, Your Honor.
All right. I'm going to do it. I think you can do it.
Me too.
Okay?
Understand.
I'm going to reinstate your previous bond where you were previously at home, right? They'll have to do that because you don't have a tether on now, right?
That's correct.
Okay, so they'll have to fit you with a new one prior to your release.
All right. Thank you, Your Honor.
Okay? Don't let me down.
Yes, sir.
Your Honor, may I add one thing? After consulting with Mr. Peoples' family, they are asking the court if Mr. Peoples has any kind of crisis or something like that, if he can be transported to Trinity, Ann Arbor without necessarily violating a confinement order.
Response?
We addressed this, I think, at the last hearing. If Mr. Peoples needed to get seek help at the hospital, that wasn't going to be an issue regardless. He would just they would simply need to notify community corrections of what happened and where they are. And if there were any sorts of deviances from the home confinement zone, I think that was the plan, so that the court would be apprised of what was happening. But the tether conditions ought to remain the same.
Actually, what happened last time was the public defender came up on our Mr. Peoples' behalf with a communication from CMH and a request, I believe, from his family that they're aware of certain triggering events for Mr. Peoples. That on those triggering events arising, what they were looking for was some leeway from the court to allow them to take what action, not necessarily, I mean, if they had to go to Trinity, that's fine. That's a medical thing at that point. But from what I understood and what was explained to the court, sometimes it may just be a walk just to kind of bring him back. I mean, I'm not using medical terms, but yeah, I think you get what I meant. My understanding is, as we were looking at that, is the people were absolutely not in agreement with that.
That's not correct, Your Honor. The request.
Well, that's what you said.
The request for.
That's what you said at the bench. If you're telling me I'm wrong, then you better be clear, Jade, right now.
I will be clear right now, Your Honor. What I said was no to the request for a tracking tether, not for home confinement. That's what I disagreed with.
When he asked whether or not they could leave, you objected vehemently, which is why I came to the decision that what I was going to do, and I made it very clear, we'll bring him in here. Because what I told him very clearly is, fine, you can ask for permission, but maybe we're just in a situation to ask for forgiveness. Let the family do what they need to do. That's what you said. That was your objection.
I'm not disagreeing with that part. Their request for a tracking tether change.
Stop talking. You hop one more time and we're going to have a problem. Childers, McDuffie, Mr. Brown, Miss Yagi, my chamber. In here. All rise.
We're CJ Judicial County of Washington State of Michigan, about back in 17.
You may be seated. Peoples.
Reverend joining me right now in your pocket.
Your Honor, I'm very familiar with Mr. Peoples' case if the court wants to proceed.
All right. Ms. Douglas is now here on behalf of people on this one. So I think we can finish this up. Here's what I'm doing. His new case had $100,000 bond. I'm going to make his bond in his new case match the bond with the conditions in his other case so that he can be released, because otherwise he would be held on that. He'll be refitted with a GPS home confinement tether prior to release. My understanding is the family can pay the $175 to community corrections, so they'll get that paid and all prior conditions are reinstated. And then we need a new date. It's actually going to be October 30th.
Okay.
It's going to be our date. Anything else on this matter?
Nothing from the defense, Your Honor.
All right. And Samuel, you told me you're going to do it, right?
Yes, Your Honor.
All right. Okay. Thank you.
Following a tense disagreement between Assistant Prosecutor Ms. McDuffie and Judge Simpson regarding statements allegedly made during an earlier hearing, Judge Simpson directed both the prosecution and defense attorneys to join him in chambers. When the parties returned to the courtroom, a different assistant prosecutor had replaced Ms. McDuffie and proceeded with the remainder of the hearing. A judge's decision to move a dispute into chambers is a common courtroom management tool. It allows concerns about attorney conduct or courtroom decorum to be addressed privately, helping prevent unnecessary escalation in front of the public while maintaining the dignity of the proceedings. Importantly, judges must still follow strict ethical rules. Under Canon 3A.5 of the Michigan Code of Judicial Conduct, a judge may not initiate, permit, or consider ex parte communications regarding a pending case. In simple terms, a judge cannot discuss the substance of a case with one party or attorney without the other side being present. By bringing both the prosecution and defense into chambers together, Judge Simpson was able to address the conflict outside the public courtroom while ensuring that neither side was excluded. This approach allowed the issue to be handled privately without violating the prohibition against improper ex parte communications. Although the 3 courtroom incidents discussed in this video arose from very different circumstances, they all highlight the same fundamental principle: the courtroom operates under the authority of the judge. When attorneys believe a judge has made an incorrect ruling, whether involving sanctions, evidentiary issues, or courtroom management, the legal system provides specific and structured methods for challenging those decisions. Attorneys may place objections on the record, file motions for reconsideration, and, in some situations, seek review from an appellate court. What attorneys cannot do is continue arguing after a ruling has been made, escalate a disagreement into a personal confrontation, or repeatedly challenge the judge after being instructed to move on. Those decisions can carry immediate and serious consequences. Depending on the circumstances, an attorney may face financial sanctions, removal from counsel table in front of a jury, or a formal judicial reprimand. Such outcomes can affect both the attorney's professional reputation and the client's interests. Judges are not infallible. Trial judges sometimes make mistakes, which is precisely why appellate courts exist. However, the courtroom itself is rarely the place where those disputes are ultimately won. The most effective tools available to an attorney are the record, the motion, and the appeal. Attempts to challenge a judge through direct confrontation, no matter how understandable the frustration may feel in the moment, often lead to results that benefit neither the attorney nor the client. If there is a courtroom exchange or legal case you would like us to analyze in a future video, let us know in the comments below. And if you enjoyed this breakdown, don't forget to like, subscribe, and join us as we continue exploring the legal system and helping foster a more informed society.